Non-voting delegate, the representative from the District of Columbia, Eleanor Holmes Norton, 4 minutes.
The lady is recognized.
I thank my good friend for yielding to me, and I strongly oppose this radical, undemocratic, and paternalistic bill, as do the 3 top local elected District of Columbia officials, Mayor Muriel Bowser, Council Chair Phil Mendelson, and D.C. Attorney General Brian Schwab. I ask unanimous consent to insert into the record their joint letter opposing this bill.
Objection.
Before I discuss the substance of this bill, I want to discuss democracy and the lack of it in the District of Columbia. D.C. residents who have all the obligations of American citizenship have no voting representation in Congress, and Congress has the ultimate say on local D.C. matters. While my Republican colleagues are correct that Congress has the constitutional authority to legislate on local D.C. matters, their assertion that Congress has a constitutional duty to do so is simply wrong. Legislating on local D.C. matters is a choice. As the Supreme Court held in 1953, and I'm quoting, "There is no constitutional barrier to the delegation by the Congress of the District to the District of Columbia to full legislative power," end quote. D.C.'s local legislature, the council, has 13 members. The members are elected by D.C. residents. If D.C. residents do not like how the members vote, they can vote them out of office. That is called democracy. Congress has 535 voting members. The members are elected by residents of their states. None are elected by D.C. residents. If D.C. residents do not like how members vote on local matters, they cannot vote them out of office. That is the antithesis of democracy. The merits of this bill should be irrelevant, since there is never justification for Congress legislating on local D.C. matters. However, I will discuss the bill. This bill would be the biggest rollback of D.C. self-government in a generation. This bill says the D.C. Council may not, and here I'm quoting, enact any act, resolution, or rule to change any criminal liability sentence in effect on the date of the enactment of the D.C. Crimes Act of 2024, end quote. This provision, which does not define the term criminal liability sentence, is as poorly drafted as it is offensive. It takes away D.C.'s authority to increase or decrease statutory criminal penalties. If D.C. wanted to increase penalties for violent crime, it could not do so. This bill could even be construed to prevent D.C. from establishing any new crimes at all. This bill also reduces the maximum age of eligibility for DC's Youth Rehabilitation Amendment Act of 1985. D.C. is not the only jurisdiction to have such a so-called young adult offender law. Alabama, Florida, Michigan, New York, South Carolina, and Vermont have such laws. The sponsor of this bill is from one of those 6 states. The Revolutionary War was fought to give consent of the governed and to end.
I'll grant the lady an additional 30 seconds.
Objection.
To end taxation without representation, yet D.C. residents cannot consent to any action taken by Congress to pay full federal taxes. Indeed, D.C. pays more federal taxes per capita than any state and more total federal taxes than 20 states. If House Republicans cared about democratic principles or D.C. residents, they would bring to the floor my D.C. statehood bill, H.R. 51, the Washington, D.C. Admission Act, which would give D.C. residents voting representation in Congress and full local self-government. Congress has the constitutional authority to admit the state of Washington, D.C. It simply lacks the will.
Reserves. Gentleman from Florida is recognized.